Afternoon, everyone. Sorry for the hiccup of the change in the session, and I do thank the chair of the course as well as my chair co-speakers for the swap. I know it's been a long day for you, for us. And I hope that this can still be digested, knowing that there's yet another session. So I will not be the culprit, the ultimate culprit. I hope tonight or this afternoon. So the idea of these presentations developed out of, I think, pure chance, really, where we thought that Igor and myself thought that we could look at what's been going on following the Ever Given. Mostly it's given rise to these presentations, and Hayan's also work on salvage it inspired us also to give these updates every now and then, or every year. So I've chosen obviously a selection of cases, mostly from common law courts, even though my intent was to spread it out, because I do believe that we should be shopping around, and that we should, in a sort of a post-colonial approach. Sorry, Zoran. I feel that there's a lot of potential for countries, especially developing countries. It's good to know that nowadays there's a very long waiting time, because that means that other courts, other countries have a chance also to render justice. Anyway, Casualty. I know that we had a bit of a. I missed the session this morning on that update regarding the Ever Given. I'll come back to some aspects of that case in the course of these selected cases. So I think I want to begin with a very interesting case that was rendered by the UK Supreme Court, touching on difficult concepts of sovereign immunity in relation to salvaged cargo. So the case, interestingly, goes back to the 1940s, when a vessel carrying silver bullion was transporting that cargo, as well as other things, and over 700 people to South Africa, on the notion that the South African government of the time owned the silver, which was intended to be turned into coins. And that vessel was torpedoed by a Japanese military, and so it sank, and obviously a lot of people died as well, and the silver, the silver went down also with the vessel. So in the late the last few years, the salvage operation was delivered, or was rendered, and the cargo of silver was actually retrieved. Obviously, it has a lot of value, so there was a lot of interest. The operation ended up by offloading the silver in Southampton, where the silver was handed over to the receiver of wreck, as it should be, by virtue of one of the Merchant Shipping Acts. And then there was like a period of time for the owner of the wreck to claim ownership, which was done by the current South African, the Republic of South Africa, as the successor to the South African government of the time. And the case went through all the levels of jurisdiction, between the salvo of the silver and the owner of the, or the presumed owner, or the presumed owner of the silver bullion. The case, I think, what it does is it has huge developments on sovereign immunity in common law as well as the international law, and it also goes into the relationship with salvaged cargo. So the main question for the various levels of jurisdiction was whether the in rem proceedings was, so basically the salvo started proceedings in rem against the silver to claim salvage rights in it. And the Republic of South Africa claimed that the cargo, by virtue of an act of the UK, that cargo belonged to a sovereign state, and therefore it was subject to sovereign immunity, and therefore it could not be validly the subject of any private claim. And that was the court for the court to answer. So the Supreme Court actually reversed the lower courts, including the Court of Appeal, where there was a dissent, holding that the cargo of silver was actually subject to state or sovereign immunity. So all played on a particular provision of the Act providing for sovereign immunity, and that provision of the UK legislation simply said that where cargo and the vessel on which the cargo is being carried are used or intended for a commercial purpose, then that is an exception to the state or the sovereign immunity. So obviously the salvo was trying to benefit from that exception to sovereign immunity, but they failed at in front of the Lords of the Supreme Court. So what was crucial, according to the Supreme Court, was the time for determining whether the cargo was being used for a commercial purpose. Was the time at which the cause of action arose. And when was that? According to the Supreme Court, that was the time when the salvage operation took place. So 2017. I think that's fair. That's when we lawyers are used to holding legal evaluations back to the time when the cause of action arose. However, in the lower courts, there was a different, obviously, opinion on that. So, but the court eventually said anyway that goes back to the shipment in 1942, because there was no change in the destination, if you like, or the status of the cargo since the cargo sank with the rest of the ship to the bottom of the sea. So the lordships had to look at the use or intended use of the cargo and the vessel on which it was being carried back at the time of the shipment or the contract of carriage. So we learn from the facts that so the South African government was bringing this silver from India to South Africa to mint it as coins. under contracts of carriage, commercial contracts. So there was a lot of confusion that in itself, as soon as you have a contract of carriage with bills of lading, that turns it into a cargo used or intended to be used for commercial purposes. That's what the lower courts held, and they were overruled by the UK Supreme Court, saying that's a fallacious argument. Because we use commercial contracts of carriage for everything. So they had to look at the proper use. And quite honestly, it was difficult to deny the fact that there was no commercial intent. The South African government was bringing over the silver to turn it into coins. And that was the epitome of a sovereign act. So that's where the claimant, the salvos, failed to convince the Supreme Court that they could benefit from the exception to state immunity. And I think I can maybe leave it at that and move to the next case. Right, as this topic is obviously on casualties, we have I've been looking at everything related to wet shipping. So there's been quite a few collisions, including the Dali that several speakers talked about. Yesterday you had Filippo Lorenzon, which I'll come back to. I think that this is a very dynamic area of maritime law, to be frank. I don't know whether it is evidence of the sustainability and the green shipping or the blue economy, because there seems to be a lot of casualties, at least from this quick overview that I'm providing to the benefit of this course. So a court in Ireland settled a claim on a collision between a fishing vessel, a small fishing vessel, and a much larger bulk carrier. So this happened off the coast of Ireland, and the applicable law was deemed to be the Irish law. For all intents and purposes, it was the Cole Regs, which had been the collision regulations, which is an international convention of the IMO, incorporated into Irish law. And the interesting feature of this case, so a typical collision between two vessels, and there was a long-held view in the old days that when vessels approach fishing boats, they should be be very careful, and they should yield or just sort of be extremely proactive in avoiding a collision. Interestingly, the judge in this court said that this was no longer the proper rule, that over the course of the years, in fact, the collision regulations had been amended. And nowadays, fishing boats do not deserve a special care by other vessels. Because this was obviously, you will guess that the fishing vessel was very largely at fault in this case. And when you read the judgment, you realize they were very reckless. They were using a trawler on the seabed, and they were being observed by the larger bulker, which was in the vicinity. So while they were obviously, trawling is a very dangerous operation, so it could in fact lead to it would require care by approaching vessels, and I think that rule remains so in the Cole Regs, but that But the fishing vessel in this case, what they did, they kind of without warning, they decided to remove the trawl and shift to another location, and they changed their course very very suddenly by increasing the speed, and that obviously led to the collision to a large extent. So the judge was keen to blame to a larger degree in terms of, and that was like in up to 85%, the fishing vessel. They still held the other vessel, the bulker, to some degree of fault, because even though that vessel was observing the fishing trawler, and they were taken aback with the sudden movements of the fishing vessel, they could have somehow, according to the court, done more in terms of avoidance. And I think this court sends a good signal in the sense that no one can sit back when faced with a potential collision, and I think it signals the need for proactivity on the part of all the vessels involved. And I think that has been a trend in all the cases that I have picked on in this summary today. So what we have is, okay, perhaps we can move to the next one. Dragging anchor, another illustration. What is it? Yeah, so an anchor drags in nautical terms, and I yield here to all of you who have better nautical knowledge than myself. I had to look it up properly. So basically, you drop the anchor. A vessel will drop the anchor, and that will usually provide some stability, right, to the vessel, because the vessel is kind of will stop moving. But when the anchor drags, that's a bad sign. It means that the anchor has lost its grip on the seabed. So this is an illustration of such an incident. There were two vessels off Bangladesh, and the Bel Parai was the more culpable vessel in the collision that occurred. They were the two vessels, Bel Parai and Kiran, Australia, were actually in the same anchorage, and they had both dropped their anchors, obviously. So the Bel Parai, however, was dragging its anchor, so it had a problem with its anchor. It wasn't working, so it was starting to shift. On top of that, to make things worse, the engine of the Bel Parai was malfunctioning, started being not working, not responding, and all of this happened just before midnight. And it seems that they took, the people on board the Bel Parai took their time to contact the neighboring vessel, which was the Kiran, Australia, that there was a situation which was going to lead to a collision because it was drifting towards, obviously, the Kiran, Australia. They somehow took their time to call them. In fact, it was the Kiran, Australia that initiated the call. They didn't respond, so they called back. And in the midst of all of this, Bel Parai was frantically, apparently, I don't know if they were frantically trying, but they tried to call port assistance, but there was no response. There was the port assistance called back like half an hour later, which in the meantime, the collision had happened. So just in the midst of like in the matter of an hour or so, all of this happened right after midnight. So there's a case law in the English courts about dragging anchors. And it says that when an anchor drags, it does not automatically mean that the fault lies with the vessel whose anchor is dragging. But they have to prove that they were not at fault. And this they failed to prove in this case. So they applied the old rule regarding that. And then the rest of the, I mean, this was, I don't think that this was dispositive of the whole issue of apportionment of liability. It was just a presumption, because the fact that the anchor drags, of course, that carried a certain blame, because the Bel Parais was not able to rebut the presumption that they were at fault, and they could have done that. But that in itself did not necessarily lead to the collision. So that was another consideration by the court. And if we go through the judgment, we will see that the judge was quite strict on the conduct of the crew of the Bel Parais following the discovery of the issues that they were facing. They could have warned, as I said earlier, the neighboring vessel of the situation earlier, and that, according to the judge, could have simply avoided the collision. Now, again, the judge did attribute some measure of fault to the Quran Australia for, again, failing to take evasive action. I think that my colleague may have already touched upon this. The Ever Given, which gives ever more judgments in the courts. We had in earlier this year in March a judgment of the Court of Appeal. I believe that at the last Dubrovnik course, I had given this the comment on the lower court's judgment.
The conference is split.
Oh, maybe at the split. Okay, you have better memory. Thank you. I bow to that. So we have. It's not major news. I think the lower court judge had already decided in the first proper contest, I think, in a legal court, in a court of law, on the salvage claims already last year, that there was no salvage contract concluded between Smith, which is the salvo, and the owners / managers of the Ever Given in the Suez Canal. You know, as you heard, it blocked the canal for 6 days, and eventually it was refloated thanks to, I think, mostly the salvos efforts. So they had already won in last year, and the Court of Appeal confirmed the decree of the first judge, saying that there had been no contract concluded, which is what the salvos wanted. The salvos wanted to claim higher than what they were trying to negotiate with the owners of the vessel as a remuneration, because, as you know, salvage convention, salvage in common law may give rise to a higher award of salvage than most commercial agreements. And the last bit on this slide just is a bit of harking back to what the judge in the first instance had found. Yes, usually in situations of casualty, you would expect that things have to be done quickly, right? But the judge actually said, yes, they were trying to do that as quickly as possible. You know, they were responding to each other. The salvos in Europe, and then the owners in Japan. They were, sending emails within a few minutes of each other. So that was very quick. But the judge did say that there was urgency, but they had time to reach an agreement, and yet they didn't reach it. Okay, so that actually negated the existence of a contract, which was the lucky day for Smith. I think I'm now moving away from salvage into just a few more cases. An interesting illustration from Singapore. Thank you, Singapore, for rising up to the challenge of. Obviously, Singapore. We can view it as the little baby of the English courts.
Big baby.
Oh, the big baby. Yes. So this is a BIMCO. Interestingly, a BIMCO contract form with a clause. A choice of law clause pointing to Singapore and the forum clause pointing to the Singapore courts. And that's why it was the Singapore court that rendered this judgment. This was a vessel that was already in a very bad condition. So interestingly, the salvo or the claimant entered into a contract with the vessel owner, first on a form called Rec Fixed 2010. That's like a contractual standard form that may be used by owners of vessels and wreck removers, if you like, or salvos, because salvos can do that job. The REC family of BIMCO forms is much newer than the salvage agreements. So this is an interesting case where these REC removal standard forms are actually being used. The operations under the Rec Fix 2010 were kind of unsuccessful because the parties just dropped that contract and they decided to enter into a new contract, which was the Rec Stage 2010, which is depicted in the second main large paragraph on the slide. And as its name suggests, stages. There are stages in the wreck removal operation contract. The stages include installments to be paid by the owner of the vessel to the wreck remover or the contractor. It's a bit different from salvage, if you like. So it's not a salvage agreement as such. It's a contract for works. One could argue. There was, however, the contract definitely described the various stages of the operation of removing the cargo from the holds of the vessel. That was obviously a big issue. There was a lot of fiber wood inside the holds of the vessel. So for the vessel to be refloated properly, it had to be lightened through the removal of that cargo. So the contract did describe stages of emptying of the cargo holds, and very importantly, payments had to be made at different stages to the contractor. There was also a clause requiring the owner of the vessel to nominate another type of contractor to remove hazardous waste. This they didn't do. Not only that, they also failed in making the payments as they were supposed to. So this led to the suspension of the works by the other party to the contract, the contractor to the Rec Stage form. And they got the judgment by the default against the owner. Things were fine, but then the owner found out about the default judgment, so they applied for an order to set aside that default judgment, and they won. And that's that. This is the case. So the courts came to the conclusion that they were at prima facie, because remember that the degree of determination of these requests for setting aside have to be carried out on a prima facie level. So the Singaporean court was of the view that the owner was not had not been in bad faith, that they had legitimately not heard of the judgment. So that was good. And they said that in any case, the fact that they had not appointed the contractor for the hazardous waste, that actually, even though it was a default on their part, it did raise a potential for defenses against the claim of the salvo, of the contractor. And in any case, not all the stages of the removal of the cargo that were put into the contract had been performed by the contractor. So the judgment was the judgment by default was set aside, and the case is presumably now being argued on the merits with parties fully represented. I think that it was interesting that in this court, you can see it from the last paragraph, that the court actually relied heavily on doctrine, that we call it, or the legal literature of Gaskell, and the description of the wreck removal contracts. So if you want a good understanding, I think, of wreck removal contracts, you may check out this particular judgment. Let me move, I think, to the last case that I'm dealing with in terms of the rulings of the court. I don't know if this qualifies under casualty. We can have a discussion about that. York Antwerp rules, general average. I'll be ending in just a few minutes. Is that all right? So just to summarize it, a court in the commercial court that Ridian was referring to determined that, in fact, a bill of lading that mentioned general average will be regulated by York Antwerp Rules 1994 and subsequent modifications. That includes the very latest version of the York Antwerp Rules, and they actually agreed with the insurers in the case, but obviously to the dismay of the ship owners. So I think that's what we look at, what I want to say, get out of this judgment. This is happening now in the Red Sea. The empty motor tanker, oil tanker Sunyan is still on fire. It was struck. It caught fire because initially it was actually it was hijacked. It was boarded by unknown elements of a vessel. We don't know whether they were Yemenis or they were actually maybe pirates, but eventually the Yemeni armed forces did rig the vessel with bombs, and that's what set fire to the oil on board. This is a very complicated situation now. It's unfolding. The salvos are very reluctant to intervene. The US, the EU, even the Yemeni, the Houthis are actually being approached or trying to find a solution to this. So we will have more cases to talk about. And I think the last one is I don't see it. The Dali, which I should have it. The Dali, there was the U.S. Department of Justice just filed a lawsuit against the Dali, the owner of the Dali, even though that we know that the Dali can benefit from limitation of liability in the U.S., which is much less than in terms of the LLMC. This only happened, I think, in the last 2 days. The U.S. government is suing, therefore, the vessel owners for that, following that elision. They call it elision in U.S. law. A ship colliding with a vessel, with a bridge, and they claim that the crew were notoriously incompetent. So and they did other very serious faults. And I think they're trying to break the limit, obviously. Yeah. And I think this brings me to conclude my presentation. Thank you all. Thank you.